Thanks very much indeed, and thanks very much to the Institute and to all involved for the very kind invitation to speak a few words here today. I'm always tempted after Peter Sutherland speaks to simply say I agree and have nothing further to add, an approach that was beloved of a now long retired Supreme Court judge who was beloved for exactly that reason by every law student I knew. But if I do that, they certainly won't invite me back again, so I suppose I'd better say something. I read with great interest your paper and agreed with nearly everything you had to say in it, Peter. One particular point that your mention of refusals of treaties often on the basis of arguments like neutrality, taxation or moral issues that have absolutely no substance rang very true for me. I do remember sitting down in April, I think 2008, which was around the time of the first Lisbon Treaty, and writing down the arguments that were being considered. And the striking feature about most of them was that they had absolutely nothing to do with the treaty. Farmers were arguing about the stance of the government in the WTO talks. Unions were talking about reversing a particularly controversial decision relating to collective bargaining. Hospital committees were trying to stop closures of hospitals. The usual arguments about neutrality came out. A completely fake argument about corporate taxation somehow took root. And then the argument about a commission membership that actually had already been decided in the Nice Treaty without anyone seeming to get too worked up about it. The arguments over the fiscal treaty struck me as being much more closely related to the substance of the treaty, and yet I agree that they too frequently diverged from reality and completely and utterly factually incorrect arguments about the economic argument of that treaty, which in reality was very limited, were constantly made. For me, all of this involves a kind of call for realism in relation to things. And I think we need to be realistic not just about our membership of the European Union, but about the advantages and disadvantages of the legal mechanism of a referendum as a decision-making tool. Of course, referendums do have advantages. The big advantage of a referendum is its finality. There's no arguing with the result. So when it comes to a really big decision like entry into the Union or matters like that, there's no they are a useful tool, but the disadvantages of them are that the arguments deployed in them are frequently ill-informed. They're plagued by propagandistic measures like referring to a treaty as the austerity treaty, whether it is or not, and they can be affected by attitudes to the government, and furthermore there is the issue that they're also affected by the extent of the individual's knowledge about the issue in question. In other words, people who don't know, and we have research confirming this, really do tend to vote no, and participation rates also can vary very wildly as well. So there are advantages, there are disadvantages. I know I've stressed the disadvantages there, but there are advantages. What I would say is that we need to avoid deifying referendums at the end of the day, and I think that was a danger perhaps that perhaps wasn't the Supreme Court, particularly in McCann number 2, might not have been alert enough to. I think it was Bismarck who said that those who love sausages and respect the law should never watch either being made. Perhaps the Supreme Court decision in McCann number 2 seemed to be made somewhat in blessed ignorance of the reality that if you exclude government finance from referendums, well then private finance will flood in to fill the vacuum. I'm not sure, one perhaps point of dissent, I'm not absolutely sure about the conclusion that we could reasonably have avoided referendums on the basis of the essential scope or objectives test in Crotty. I've been asked that question and have asked myself that question quite frequently. There's a good discussion of it in Kelly's Irish Constitution, in which the authors, now Judge Hogan, and Jerry White conclude that maybe the referendum on the Nice Treaty was avoidable under the Crotty criteria, but they're less sure about the others. For example, the Lisbon Treaty involved setting up a new European Union, a new, legally speaking at least, so I'm not sure if that could have been done without a referendum authorisation. I suppose the whole point for me about the Crotty essential scopes or objectives test is ultimately that it is so ambiguous, it's effectively as wide as a gate. So we don't know how wide or narrow the essential scope of our objectives of particular treaties are. Although, like Peter Sutherland, I'd be more inclined to give the concept a wide rather than a narrow interpretation, because after all, if you vote for a kitten, I suppose you shouldn't be too surprised to wake up in the morning and find that it has grown into a cat. But the only way you get to find out about such matters is when the courts get to pronounce on it, on the essential scope or objectives of a treaty. And of course, the courts never actually get to pronounce on that, because no Attorney General and no government would ever risk getting it wrong. In other words, risk mere parliamentary ratification of a treaty that might go beyond the essential scope or objectives of existing treaties. An Attorney General who advises in favour of a referendum will never be found out as having been wrong, as having made a mistake. An Attorney General who advises a referendum is not required, might be. And in the result, I think that the Crotty test that's really applied is not, does this treaty go beyond the essential scope or objectives of existing treaties? The real test that's being applied is there any reasonable possibility at all that this treaty might go beyond the essential scope or objectives of existing treaties? And that test is always met, and therefore we almost always get referendums. How do we get out of this danger of unnecessary referendums? Well, I think, as was mentioned by Peter, Alan Chatter's suggestion, which I think might have been modelled on an equivalent procedure that exists in European Union law, preliminary references to the Supreme Court on the legality of Ireland's adherence or ratification of a treaty would eliminate any danger of superfluous referendums. Of course, to get that preliminary reference, you'd actually require a referendum in the first place. Would an amendment like that actually pass? Answer to that, I don't know. There's a very large body of opinion that there is no such thing as a superfluous referendum, so maybe it wouldn't pass, maybe it would, I don't know. I think it would be a good idea to have it personally myself, though. Going back over the substance of what Peter had to say, I think Ireland has had for a long time a worrying triumvirate of decisions. The Crotty decision, the McCann No. 2 decision, and the Coughlin decision. I think it's fair enough to say that all decisions were controversial enough when made, probably in descending orders of magnitude, but particularly in legal circles, I think I find that is increasingly less the case. The Crotty case was significant, of course, for a number of reasons. In relation to its decision in relation to standing, because it elaborated the scope of the necessitated clause in Article 29.4, establishing essentially its irrelevance in cases of treaty amendments, because it elaborated the scope of the constitutional authorisation to join European organisations, with Chief Justice Finlay's famous formulation that interpreting that as only allowing access to existing treaties would be too narrow, interpreting as allowing access to any further treaty amendments would be interpreting it too widely, and coming up with the essential scope or objectives test as well. But the real reason why Crotty, of course, was controversial was its approach to sovereignty. And interpreting this as simply being the right to say yes or no to matters. The problem is, as Peter Sutherland has indicated, it's impossible, I think, to believe that even such a rigorous test as seems to have been established in Crotty, was actually violated by Title 3 of the Single European Act. It's full of what some would pejoratively call weasel words. In other words, diplomatic formulations designed to ensure that no real obligation to do anything at all exists. So in other words, it's a wish list of rubber formulations mandating little more than fireside chats about foreign policy. So I think it's fair to say that the Crotty test really was a hair-trigger approach to sovereignty. And if the essential scope or objective test was exceeded, then it was likely that the sovereignty test was going to be impossible to escape. That's especially since the area of foreign policy is interpreted at times as being so wide. And of course, it's important to remember that the Crotty test doesn't just apply in the area of foreign policy. It talks about decision holders giving away their power, if you like, being custodians of the power to decide, but not being entitled to hand them over. But that obligation applies to the legislature and it applies to the executive as well. Now, of course, the immediate damage of the Crotty case in this regard was done away with by the referendum that passed the Single European Act afterwards, or approved it, and then successive referendums, if you like, approving successive European treaties. But it remains a very real consideration, the Crotty case. It was real. It's real in relation to treaties which are not European treaties. And of course, that was the case with the Fiscal Treaty. Of course, the big point about the Fiscal Treaty is that it didn't need to be ratified by every member state. And it's likely, in my view, in the future, that recourse may be had to treaties of this kind again in the future, because European Union treaties need to be ratified by everyone, and it's eminently possible that in order to escape, if you like, that requirement of unanimity, that there will be future treaties, there will be treaties in the future, in other words, which the validity of which will rest squarely on the Crotty sovereignty test at the end of the day. So it's a very relevant test indeed. Interestingly, in the subsequent Majimsi test, which was a challenge to the Anglo-Irish Agreement, which should have been condemned if pure Crotty was applied, the Supreme Court ran a mile from it and distinguished it in a very unconvincing fashion as well. And I find it interestingly as well that in the latest judgment, the Pringle case, the Supreme Court distinguished it as well. Again, very, very unconvincingly. I find the interpretation of Mr. Justice Hardiman, his interpretation, if you like, of the in that regard, of the Crotty test, a more convincing one, although I prefer the outcome of the majority's decision in that particular case. It's just I don't believe the distinction they drew in the case between the ESM Treaty and Title III of the SEA. The McCann No. 2 case, what I suppose I should say basically in relation to the McCann No. 2 case and the Coughlin case is that I agree and really haven't a great deal further to add in relation to them. I suppose my essential concern would differ somewhat from Peter Sutherland's in relation to the McKenna case. This is the one relating to expenditure in referendums. I suppose I share the difficulty that I fail to see where the Supreme Court got its justification for this very radical definition of democracy that it came up with. This was very real judicial legislation, and I think of a rather unwise kind. But where I would differ from Peter Sutherland a little bit, or perhaps I wouldn't differ, it's just that he didn't mention this, is that my view of the McKenna case is that it has effectively privatised referendum financing, because the government, which is after all democratically elected, is prohibited from spending any money in a referendum, even though it has a very real interest in the result, whereas private parties, and we've seen this happen in successive referendums in Ireland, can come in and spend vast quantities of money in the same referendum. I find that deeply worrying. So that's the McKenna case. And then the Coughlin case, the interesting thing for me about the Coughlin case was that the Coughlin case involved an eminently reasonable rule, an attempt to balance equality and representativity. And at the end of the day, this was condemned by the Supreme Court. Again, I think very unwisely. I can't put the matter any better, I think, than Mr. Justice Barrington did in the Coughlin case when he said that the people are the ultimate sovereign, but there is no constitutional device that will ensure that their ultimate decision will be infallible or even that it will be prudent, just, or wise. The most we can hope for in relation to any sovereign, including the sovereign people, is that before making its decision, it will be well informed and well advised. In this context, to play down or neutralise the role of political leaders in favour of committed amateurs would be, to say the least, unwise. So I think that would be the main concern that I would have about those particular cases. So a fairly hefty step, if you like, away from majoritarian parliamentary democracy and into the area of direct democracy, which could have absolutely unthinkable consequences in the long term for this country. We'll have to wait and see. Now, last word. I know I've probably overgone the amount of time that's allotted to me, but a very quick word about the recent decisions, Pringle, McChrystal and Doherty. I think the most amazing thing about the Pringle case and the McChrystal case for me is that the state actually made no argument in either of these two cases that Crotty, A, Crotty, in relation to sovereignty, and B, McKenna, had actually been wrongly decided. The McChrystal case, in particular, was a more or less straightforward application. I have no query about the application of the Supreme Court as a McCann No. 2 judgment in the McChrystal case. They were right. The question wasn't whether that test, if you like, if the government's behaviour could have been approved under that particular test. I don't think it could. The question was whether that test was the appropriate one in the first place. And that argument, unfortunately, was never even made before the Supreme Court. And the result of that is we're stuck with it. In relation to the Pringle case, I found that an interesting case. Again, the Crotty case was questioned by neither side in the ruling, and I think that's very interesting. But interestingly, the majority and the minority, the one-man majority consisting, or the one-judge majority consisting of Judge Hardiman, took very different views of what the sovereignty test actually established. I think Mr. Justice Hardiman took a more traditional view of what it established, but Mr. Justice Clarke instead focused on the breadth of the decision. In other words, the breadth of Title III of the Single European Act, and that was the objectionable feature to it. In other words, that the European the European Stability Mechanism Treaty was quite narrowly focused, and I know I am simplifying here to a certain extent, but that the Title III of the Single European Act was a much broader measure affecting foreign policy as a whole, and that was the distinction between them. So for Mr. Justice Clarke, and if you're reading the judgments of Justice O'Donnell and Mr. Justice Clarke are by far the most interesting ones there. The new test established by Mr. Justice Clarke at page 28, so there you don't even have to read the whole thing. The new test was to distinguish between an exercise in sovereignty on the one hand, which he felt that the ESM treaty was, and whether there was, and he felt that there had been this in relation to the Single European Act, Title III, such a significant narrowing of future policy options that it can properly be said that there has been a transfer or pooling of sovereignty. My problem with this particular test, I actually think it's a much wiser judgment than the initial judgments in the Crotty test. But the problem is, it is also a very difficult test to apply at the end of the day. Where is the borderline between the two of these? So I think, if you like, the uncertainty that we have been left with in relation to such matters as a result of the Crotty case is going to survive, and I think we are going to see plenty more referendums. Thank you very much indeed.